Good morning to all of you. This video is for law of tort students. Welcome to Legal Matters by Sai Baba Sunkara. Today we are going to discuss a simple concept called as tortious conspiracy. Please remember, it is only tortious conspiracy, not conspiracy. In my previous video, I told you 120B of the Indian Penal Code. It is a criminal conspiracy. So it is a very, very serious offense. But here, lesser thing. But in torts, what is the conspiracy? You have to learn. When two or more persons conjointly agree to commit an act, why? To cause injury or harm to any other person. Here, meeting of minds of people is there. When two or more people agree to cause harm to the third person, what for? To third person or property or his business. By any unlawful means, it is called tortious conspiracy. That means సహజంగా మనకి ఎదుటివాడు బాగుంటే వ్యాపారంలో ప్రొఫెషనల్ జెలసీ ఆర్ బిజినెస్ దాంట్లో చాలా జెలసీస్ ఉంటాయి. ఎదుటివాడు బాగుపడతాని చెప్పి చాలామంది ఇబ్బందులు పెడుతూ ఉంటారు. దిస్ ఈజ్ వాట్ ఈస్ కాల్డ్ tortious conspiracy, not criminal conspiracy. Right? So, please remember, Huntley versus Thornton, very famous case. Huntley versus Thornton, 1957. Right. So, Mr. Huntley, after joining some department, he became, this is relating to dockyard. So, he became a member of the union. So, this union is called the Federation of Shipbuilding and Engineering Union. Right? For some time it's okay. And the union called for a strike against the management because when the workers of the association went for or requested for the wage hike or wage increase, the employers did not agree. Therefore, these people wanted to go on strike. But Huntley said, they are giving enough salary. Why should I go for strike? This is not the time for going strike. So he refused to participate in the strike. And the fellow union members, they got extremely angry. And actually, they went to the employer and requested him or demanded him to dismiss this fellow. But the employer, he refused to do so. At least there is one person who is supporting the management. Why should we dismiss him? No, we are not going to do it. Then the union, district committee of the union, so informed or requested the apex or executive council, you can say EC members, to once again to remove him or to expel him from the union for his arrogant behavior or for not participating in the strike. But incidentally, the EC also did not agree. Rebo is a newly joined person, he has got some, okay, let him go, we are there. So ultimately, so this here also they were not successful. So therefore, the union members conspired and made him stay away from work. They did not give him any work. So akkada తెలివితేటలు ప్రయోగించి వాడికి వర్క్ లేకపోతే no salary కదా. So here when he filed a case, yes, the court held it the conspiracy. The defendant union, so Thornton, that is shipbuilding and engineering union, they are liable for the conspiracy. Good. Next, another case is a negative example. This is Crowcrafter Handwoven Harris Street Co. Limited and versus Veach, 1942. So Veach is a union leader. So this is a Crowcrafter Handwoven Harris Street Co. This is a company. Right. So in the island of Lewis, that is in Scotland, this Harris Street is very famous. So actually this tweed, that is a part of wool, they used to get it from the ships from other England or Ireland, other places. They used to give the yarn to the local weavers. They used to weave the same and then they will dispose of the yarn to the factories for preparing woolen suits and coats like that. So this company is not flourishing well because the imported yarn has come. So when once the imported yarn has come, the locals, it will be not be so much of it will not be preferred by the local people. So normally manakodu ante kada imported vastunte dani meeda fashion ekku untundi, right? So actually they have sustained some loss, but whether they are in loss or not, the union people, so who is the union leader? So he requested the enforcement of their wages or enhancement of their, we can say enhancement of their wages, for which the management refused. Oh, we don't have market. Then these people, with the acceptance of the shipbuilding, the dockers union, then they stopped unloading the iron which was in the ship or which was in the port. But the Rakapati Paristenti, they are put to so much of loss. So here, this Crowcrafter, they filed a case against the union leader Veach and others, stating that they conspired to cause loss to them. But court did not agree. Why? Because collective bargaining is the main intention of the association. They will ask you, yes, you say okay or not. So when you said no, they have got their own means. So if they want to go on strike, if they want not to support you, they can do it. It is not conspiracy. So you go for a joint meeting, hold talks with them, then sort out the issue. This is the advice given by the court. It is not held to be conspiracy. And third case, you all know, Mughal Steamship Co. versus Gregory, Govanko, 1892. So we discussed whether it is a tort or not. Definitely it is not a tort because legal injury is not there. Here, Mughal Steamship Co., they were the dominant company. Actually, they were the dominant company in loading and unloading tea products in Kolkata area. So whenever the tea from China comes to the harbor, then they used to unload the same, then they used to take it to the godowns and distribute the same. This is the job. They are collecting heavy amounts as freight charges. So now this McGregor, Govanko, they have become competitors to them. They offered to take the freight at a lesser rate. So definitely the stevedores or the contractors, they used to go to this McGregor, Govanko. Now, Mughal Steamship, which was the dominant, which plays a dominant previously, they filed a case of conspiracy against McGregor, Govanko. But court said, no, they are willing, they want to give a lesser rate for the freight. Then what is the legal injury? No legal injury there. It is not a conspiracy. So it is not a civil conspiracy. And please remember, it is a damnum sine injuria. Right? Thank you very much.